Ever wondered about the legislative measures in place to safeguard women from sexual harassment at their workplaces in India? Well, today we plunge into the details of the Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal, Act 2013, an admirable act that aims to provide a safe work environment for women. The birth of this act can be traced back to a significant judgment in India, known as the Vishakha Guidelines. There were some pivotal incidents that highlighted the dire need for such guidelines. One such case involved Bhanwari Devi, a social worker in Rajasthan, who was brutally gang-raped for stopping a child marriage in her village. The local authorities turned a blind eye to her pleas for justice, which resulted in a nationwide outcry leading to the Vishakha case. These guidelines laid the foundation for the legislation. In 1997, the Supreme Court of India, in the Vishakha versus State of Rajasthan case, articulated guidelines to combat sexual harassment at workplaces. However, it took another 16 years until 2013 for these guidelines to be developed into a comprehensive law. Regrettably, even after the law was established, incidents of sexual harassment have not completely halted. For instance, a female intern accused a retired Supreme Court judge of sexual harassment in 2013, a case that rocked the judiciary and the nation. Thus, while the Act is a significant milestone, the quest for a truly safe workplace for women continues. Before we delve deeper into the Act itself, let's take a moment to appreciate some of the landmark Supreme Court judgments that paved the way for this Act. These cases not only highlighted the issue of sexual harassment at workplaces, but also laid the foundation for the legislation that we see today. Firstly, we have the Vishakha and others versus State of Rajasthan case from 1997. This case is of particular significance as it led to the formulation of the Vishakha Guidelines. These guidelines were the precursor to the Act and played a critical role in defining what constitutes sexual harassment at the workplace. Next, we have the Apparel Export Promotion Council versus A.K. Chopra case from 1999. This case expanded the definition of sexual harassment and emphasized the need for a safe work environment. It was a turning point that reiterated the importance of a woman's right to dignity, to carry out her duties without fear or harassment, and to a conducive work environment. These judgments, among others, played a crucial role in shaping the Act and ensuring the safety of women at workplaces. They highlighted the importance of acknowledging and addressing the issue of sexual harassment at the workplace, thus setting the stage for the enactment of the Sexual Harassment of Women at Workplace Act in 2013. In 2013, the Indian government enacted the Sexual Harassment of Women at Workplace Act. This act was a significant stride towards ensuring a safe and respectful work environment for women. It made it legally binding for employers to prevent, prohibit and redress sexual harassment at workplaces, and it applies to both the organised and unorganised sectors. This act defines sexual harassment broadly, including unwelcome physical contact, a demand or request for sexual favours, sexually coloured remarks, and any other unwelcome physical, verbal or non-verbal conduct of a sexual nature. A noteworthy feature of this Act is the constitution of an internal complaints committee in every organisation employing 10 or more employees. This committee is tasked with investigating and resolving complaints of sexual harassment. The Act also mandates the creation of local complaints committees at the district level to investigate complaints from establishments where the internal complaints committee has not been constituted due to having less than 10 workers, or if the complaint is against the employer himself. Now, to summarise, the Sexual Harassment of Women at Workplace Act 2013 was enacted in India to ensure a safe and respectful work environment for women. It defines sexual harassment, mandates the setting up of internal and local complaints committees, and provides for the prevention, prohibition and redressal of sexual harassment at workplaces. The Act reflects a significant milestone in the journey towards gender equality and women's empowerment. It acknowledges and addresses the issue of sexual harassment at workplaces, encouraging every woman to know her rights and to stand up against any form of sexual harassment. Remember, a safe and respectful work environment is not just a legal requirement, but a fundamental right of every woman. It is a collective responsibility to uphold this right and to ensure that every workplace in India is free from sexual harassment. Thank you for joining us today as we explored the Sexual Harassment of Women at Workplace Act 2013. Stay informed, stay empowered.